which goes back to 1328 England before then detouring to a specific law found in the post-Civil War England. Civil War England was 1640s. We're talking about the Militia Act of 1662, and then later, of course, the Glorious Revolution coming up in the later 1680s. They do this to basically build up to the point that, look, in England, historically, people could be disarmed for one of a few reasons. And the two that the court is actually focusing on here is whether whether those individuals were basically known or could be proven to be dangerous, and B, whether or not they were political opponents of the regime. Now, by the time that the Second Amendment was founded in America, 1791, the court says that basically our laws in America really only focus on people who are dangerous and not so much political opponents. I suspect a lot of people may disagree with that. 1911 Sullivan Law comes to mind, targeting a lot of folks in New York City, but hey, different story for another day. The court comments that by the 1700s to early 1800s, though, two distinct legal regimes had developed that specifically addressed firearm violence. Again, this is what the court's saying, not what Tom Grieve is saying. One is the surety laws, and I'm going to talk about that, but the surety laws and the so-called going armed laws, where the surety laws were basically treated as preventatives to prevent violence. The going armed laws were largely punitive for a pre-existing infraction. So someone does something, now they're going to be subject to the going armed laws, basically like a criminal law. So let's take a quick look at these two. The surety laws were a form of so-called preventative justice, which authorized judges and magistrates to require individuals suspected of future misbehavior to post a bond. So this is almost like probation, but of course on probation you have to be convicted of a crime to go on probation. Here you don't have to be convicted of anything. If an individual failed to post the bond, he would be jailed. If the individual did post the bond and then broke the peace, the bond would be forfeit. Surety laws could be raised and invoked to prevent all forms of violence, including spousal abuse, and also targeted the misuse of firearms, according to the United States Supreme Court. We're going to take a look at one of those laws here. These laws often offered the accused significant procedural protections, and that's important in the eyes of the Supreme Court.